All of you today. Thank you for showing up to our webinar. We at Holland and Hart are trying to educate the community on all things immigration, and so we're excited about this chance to speak with you about what's happening in the world of healthcare and immigration right now, and what everybody in HR really should know about what's going on. So with that, let's forward to the next slide. And of course, the general housekeeping rules, we're not officially your legal counsel unless you're already working with Holland and Hart. But we do want to make this interactive. And so we would invite your questions as we go along the way. You can send them through the chat feature. And of course, we will try to respond to you. If there are a lot of questions, we may find ourselves responding by email after the fact also, just to make sure that everybody's questions are answered. My name is Chris Thomas. I am a partner at Holland and Hart and head up the immigration practice here. And Sarah Belletti here is of counsel and has been in the wonderful world of immigration for 15 years now. So that makes the two of us combined. I guess we have a grand total of 40 years of immigration experience. So we're excited to be here with you today and talk through what some of the recent developments are and what we're seeing other hospital networks and clinics do to address their staffing shortages. So moving on to the next slide. We're going to cover then a few things for you. We're going to talk first about just the initial basics that everybody needs to know in terms of screening candidates in a non-discriminatory way. That's become a real hot issue, and we'll talk about that. Basics of immigrant and non-immigrant visas, want to walk you through that. And then we're going to talk about how they fit in specific categories. So we'll talk about physicians, nurses, med techs, physical therapists, and make sure that we're kind of hitting all the major areas. What we should do, of course, is tell you is that we understand that hospitals have a lot of other needs also. We recognize that you may need support with software engineers and all sorts of other positions. We're trying to hit the primary medical positions today, but everything we say about these primary medical positions could likely be applied to other types of positions that you would want to fill too. So as we go to the next slide, we'll dive into those initial screening questions. You should be aware, as you know, as you onboard anybody to come work for your organization, there are two interested federal agencies, right? The first one is the Department of Homeland Security, and what they want you to do, of course, is verify the identity and employment eligibility of anybody that you onboard. But there's another agency out there called the Department of Justice, Immigrant and Employee Rights, and they're very interested in our misuse of the I-9 process, or interested in citizenship, national origin, even immigration status related discrimination. And that can even be something that can pop up as we start diving into things such as permissible questions that we can ask. So at this point, there are really kind of 2.5 questions that we're legally allowed to ask individuals about immigration as we're trying to figure out whether somebody's going to need sponsorship or not. The first one is, are you legally authorized to work in the United States? Presumably the answer will be yes. If the answer is no, then obviously we're off to a complicated start. However, we can follow up with the next question. Will you now or in the future require sponsorship for an employment visa status, such as an H-1B visa status, to work here legally with us? If the answer to that is no, then fine. There should not be any further discussion on the subject. However, sometimes people will say, yes, I am hoping for sponsorship. And it is permissible in that context for you to say, okay, well, can you elaborate on that? And what you'll find is that people start to dive in and say, sure, I need support in a few different matters here. Right now, I am a student on a student visa. I'm hoping that you will support me on an H-1B visa. And then at least you know what you're getting into. And of course, that kind of helps you decide whether as an organization, you're willing to make that kind of investment to bring somebody on and to sponsor them. Now, questions you should not ask, of course. You should not ask questions about, so are you a U.S. citizen? It's not a good question to ask, of course, right? U.S. workers, for example, are protected, and that can include U.S. citizens, lawful permanent residents, refugees, asylees, on and on the list goes. So we want to be real careful about not asking questions that are specific, such as whether somebody's a U.S. citizen. Do you have a green card? Also not a good question. Don't want to go into the specifics about what kind of documentation somebody has before we're just going through the regular I-9 process. And of course, we shouldn't ask any specific questions about status related documents or where you are in the process, unless they volunteer that in question point 5 that I talked about a moment ago, where we asked them to elaborate. So next slide. So again, there are a few things to keep in mind. You are under no obligation to offer immigration-related sponsorship. So if you ask that second question, do you require sponsorship to work legally in the United States? And you respond, or the person responds, yes, I do. Then the question becomes, well, do we want to do this? And that's sort of the point of the conversation today. There are some considerations, right? Is there a good business reason to do this? Can't find qualified workers. We know that those of you who are attending right now are going to say, yeah, we're having a hard time finding qualified workers. And then, of course, there are the cost considerations, legal fees, government filing fees, sometimes prevailing wage requirements, and we'll get into some of those specifics as we go. And then, of course, sponsorship does not require a term of employment. So, in other words, somebody is still at will. Say that you were to bring somebody on, for example, on a 3-year H-1B visa. Well, that person may be entitled to work for you for up to 3 years, but you can terminate that person at any time. How do you avoid creating a term of employment? You don't make promises, right? You don't say, well, we'll bring you here for 3 years on an H-1B. That does start to create the idea in somebody's head that you might be creating a term. Or you could even be in a situation where you could say, yeah, you get here, we'll pursue a green card. Well, a green card can take a long time to get. And so, again, make sure that you're not making special assurances, that your recruiters in particular understand that they should not be making any kind of assurances about how long somebody would be allowed to work with you, so that we keep that at-will relationship in place. Next slide. So we're going to take a step back, recognizing that this may be more basic than a lot of you are accustomed to, but we want to make sure that we have everybody following us as we go through this. In the world of immigration or employment-based immigration, there are really only 2 general types of visas. There are non-immigrant visas, and those are temporary visas. And they essentially represent the alphabet soup. You've already heard me refer to one of them, the H-1B, but there's the O-1 visa, there's the J-1 visa, the F-1 visa, on and on the list goes of the alphabet of non-immigrant or temporary visas in the United States. There are also immigrant visas. And another word for immigrant visas are permanent visas or green cards. And those come in different categories. You'll often hear us refer to them as employment-based first category, or employment-based second category, or third category. And each of those have different requirements associated with them. And so we'll talk a little bit about those as we proceed here too. Next slide. So let's just talk briefly about the wonderful world of non-immigrant visas. You heard me talk about the alphabet soup. In the context of healthcare, there are essentially these visa categories. You've got the F-1 students. Some students who graduate, well, all students, as long as they haven't burned through curricular practical training, we'll say, as they graduate, should receive optional practical training. Now, for some people, that's only for a year, such as nurses. They'll get 1 year of optional practical training. For other individuals who graduated with us in a STEM field, science, technology, engineering, mathematics, individuals may be eligible for up to 3 years of optional practical training. And so it sort of depends on the position you're trying to fill. And we'll talk about how this relates to each of the positions as we progress here. There are J-1 exchange visitor visas. And these J-1 visas are normally what foreign medical students are required to obtain as they go through school in the United States, or med school, if we're talking about doctors. Sometimes you'll find individuals, though, who are already on F-1 visas, or maybe they're even outside of the United States and you're interested in sponsoring them to enter the United States and work with you. And that opens up a series of visas such as the H-1B visa category, the H-1B1, that's for people from Chile or Singapore, and the E3 visa for people from Australia. So those are some nice professional visas. H-1B visas, just to pause for a second, come in kind of two shapes. There's the first kind, which is cap exempt. That means you can get an H-1B visa anytime. And the way you do that is you be affiliated with a research organization or a university. So if your institution is closely affiliated with an institution of higher education, then you very well could be cap exempt and could get H-1B visas for a person at any time that is qualified to come in and work with you at your organization. On the other hand, if you're not in any way affiliated with a nonprofit research organization or with a university, then you're likely subject to what we call the numerical cap. There are 85,000 essentially H-1B visas available each fiscal year. And what happens is that a lottery is held in March now of each year, where people get to register and then find out if they're the lucky winners. Last year, the selection rate in that lottery was 23%. It's getting better because of some recent regulatory changes, so that we believe that this year the acceptance rate for those who are relying on the lottery would be closer to the 45% range, nearly 50% range this year. There are O1 visas available for the superstars, people who are kind of stand out as the superstars in the field of extraordinary ability. And then, of course, there's another type of free trade visa out there, formerly known as NAFTA, now the UMCA, I think it is, United States, Mexico, Canada, etc. Changing name, not changing anything else. The bottom line is it's a TN visa that's available for many of these healthcare related positions for Canadians and Mexicans. Moving on to the next one. So that kind of gives the crash course, the overview, and we'll now turn it over to Sarah, who's going to talk to us a little bit about the world of green cards.
Great, thanks, Chris. Yeah, so similar to the non-immigrant or temporary visa categories, there are a myriad of options in the permanent or green card type visa as well. One primary one that's probably most utilized in the employment-based context is called PERM. And what PERM is the filing of a labor certification application online with the US Department of Labor. And sort of the key aspect of that is to get through that first step, that PERM process. It requires that the employer set minimum requirements for the position, so that's specific to the job, not to the foreign national who wants to take that role on a permanent basis. And then once those minimum requirements are set, and it can be demonstrated that that foreign national meets those minimum requirements, the employer must conduct a recruitment effort and obtain a prevailing wage that's set by the Department of Labor. Because the sort of key element of PERM is the employer has to be able to demonstrate to the US Department of Labor that there's no qualified and willing US worker available to take that role. And if they can prove that through a successful recruitment effort, then there's no harm in the giving of a permanent position to a foreign national. So that's a sort of lengthy process, but is the probably most utilized path to an employment-based immigrant visa. And then once that first stage, that PERM is complete and a labor certification is obtained from the Department of Labor, the employer can then go on to filing an I-140, which is an application for an immigrant visa for the individual with United States citizenship and immigration services. And then the final step of that process for the individual to obtain their green card involves them filing an I-485 application for a green card, and that's their individual application for that green card. And so from start to finish, this process can take years. And for certain nationals that are from countries that have developed a backlog, it can take 10 plus years for nationals of India in particular, and around 5 or 6 years sometimes for nationals of China. And that's because each year the US government only gives out a certain number of employment-based green cards, and in any given year, no more than 7% can be given to nationals of one particular country. So for countries that have larger numbers of individuals who are seeking employment-based green cards, this backlog has developed. And every month, the US Department of State publishes a visa bulletin report that sort of gives information about where the backlog is at and who is eligible to apply based on the priority date that they've established through the PERM process. So that's one main, very utilized option. Another option that's available particularly to two occupations, which is nurses and physical therapists, is a Schedule A PERM. And the benefit of that is it's a streamlined process, essentially because the US Department of Labor has taken notice that there are not enough available US workers to fill nursing and physical therapy roles. So individuals in those positions benefit from a sort of blanket labor certification, where instead of having to go through all of these steps of PERM that I just described, instead the employer has to obtain a prevailing wage to show that what the minimum pay is for the individual, and they have to do a couple of the posting requirements that are normally incident to that recruitment process. But then the employer can just file a filled out PERM application with an I-140. So it's a much faster, more streamlined process to obtaining a green card for individuals who are in those two roles in particular. So that's an advantage for physical therapists and nurses. Another category that's kind of specific to the medical profession is physician national interest waivers. There's also just a normal national interest waiver, and I'll talk more about that at a later slide. We'll get into in more detail. Other options that allow an employer to avoid PERM and that recruitment test of the U.S. labor market are I-140 applications for individuals who are outstanding researchers or aliens of extraordinary ability. So what's important about those is they have very specific criteria. And for aliens of extraordinary ability in particular, the criteria in order to be eligible for that and be successful is extremely high. It essentially requires that the foreign national either have received a major international or national award to show that they have sustained a claim, or can document their acclaim by evidence of their importance in 3 of 10 categories. So those are things like publications in scholarly journals, or participating as a reviewer in peer review for a journal or other sort of medical type publication would be one example of that. Sometimes they can show proof that they command a very high salary, or that they have been cited to or contributed to a leading an institution of a distinguished reputation. So as long as they can meet 3 of those 10 categories by showing proof of their acclaim, then that's a potential for alien of extraordinary ability. An outstanding researcher is similar, where the foreign national has to be able to demonstrate 3 out of 10 categories. But for those individuals, usually they are also employed by a research institution and working in a research capacity. For example, I've filed many outstanding researcher petitions for individuals in the sciences. So often they will have published in major journals. I did one in particular for a individual who was studying soybeans and had made major breakthroughs in like crop science for soybeans. And that was, you know, particularly important because that's the major crop for many countries around the world. And so this was going to have a major impact on some agriculture and some infrastructure in terms of food security for various countries around the world. Chris, I don't know if you've had other similarly interesting cases in any of these.
Oh, we have, and we've had them in the context of physicians. As I think back on some of the physicians for whom we've done it, there have been people who are on the cutting edge of research, say possible developments and cures toward cancer, individuals who were involved in maybe a new process, a new surgical procedure that's kind of cutting edge and attracting a lot of attention in relevant journals out there, etc. So yes, if you feel like you've got a superstar or you want to bring on a superstar, we would be happy to meet with that person, kind of vet the credentials and see whether that person could qualify. There's a fascinating phenomenon out there, right? Those who qualify often think, yeah, they're probably not going to qualify. And those who do not qualify are usually the ones who are absolutely positive that they do qualify. And so sometimes we have to say, hey, you're really special, but maybe you don't have the minimum criteria to check the boxes in this one.
Yes,
So,
absolutely. We could probably go to the next slide. I had one individual in the past who wanted to do EB1A. There are certain advantages to it, especially if you're a national of India, for example, because EB1A provides EB1 classification and the employment-based green card sort of backlog. So it's a faster path sometimes to a green card for individuals that are from countries that are backlogged. And I had one individual who wanted to pursue it so badly. And I eventually told him, I'm like, when you get to 100 citations, we'll file. And within like a month, he got himself from 40 citations to 100. I have no idea how he did it, but it ended up working. Okay, so moving on to physician recruiting visa types. So Chris gave a nice primer of the various non-immigrant visa classifications, and now I'm just going to talk about it in a little more depth, specifically for physicians. So there are sort of four main non-immigrant visa categories for physicians. J1, exchange visitors in particular, is a very utilized one. J1 visas allow foreign nationals to visit the United States as exchange visitors in order to receive training or participate in internships, among other programs offered by sponsored designated by the Department of State. So that's a sort of difference with J1 versus other non-immigrant visas, is that to obtain a J1 visa, you have to have applied to a Department of State designated sponsor program. And there are many, every state has a multitude of them. But the key one for international medical graduates who pursue graduate medical education in the US for residency and fellowship training is the Educational Commission for Foreign Medical Graduates, or ECFMG. ECFMG is the only sponsor of J1 visas for physicians in clinical training programs such as residencies and fellowships, although universities can occasionally sponsor J1 visas for specific research track roles. According to data from the National Resident Matching Program in 2023, for example, there were 40,000 registrants, and of those, 17,382 were international medical graduates. So that's a pretty big percentage. All physicians who enter the U.S. in J1 status to complete graduate medical education must agree to reside physically for 2 years in their country of citizenship or last permanent residence after completion of their training before they're eligible to apply for an H1 visa, H1B visa, or L1 visa, or permanent resident status. So this is also a key difference, right? These individuals who come to the U.S. as international medical graduates on J1 status through ECFMG are all subject to a 2-year foreign residence requirement, meaning at the completion of their studies, they've agreed to return to their country for 2 years, basically to benefit their home country, right? To bring that training and that medical education back to their home country. So some of these individuals will return and fulfill this 2-year requirement in their home country, but many will seek J1 waivers. And we're going to talk about that a little more later in more detail. One sort of interesting thing is foreign national physicians in J1 status can transition to O1 status without getting this waiver, but they can only do that by attending an O1 visa appointment abroad. They can't transition status within the US. And even if they do get that O1 visa, they're still subject to this 2-year foreign residence requirement and can't transition into one of the other statuses without getting it. And I have used that before for a physician who was running out of time in J status, so we switched him to O and then later got his J1 waiver and switched him to H. So sometimes it's a multi-step process to plan for these physicians. So how does a physician obtain one of these J1 visas? So the key things are they have to pass the US MLE step 1 and 2 exams. They also have to have a valid ECFMG certificate. They also have to have a contract or official offer for a position in a program of graduate medical education or training with a medical school. And then they also have to provide a statement of need from the Ministry of Health of the country of their last permanent residence. So sort of all those steps have to come into place in order for them to secure that J1 visa. And then they can come here to fulfill their residency or their fellowship program. And they are normally granted sort of their status in 12 to 18-month increments. And usually that will go on for the duration of their training. So for some J1 physicians, it could be years, right? Depending on how long their residency or their fellowship is. I think I've seen some J1 physicians like be in that status for 5, 6, 7 years. Has that been your experience as well, Chris?
Yes, I have.
Yeah, it can be quite long. So that is the J1 visa, which is, I think, the most commonly used. Another, big category, which Chris mentioned earlier, and we'll hit on a little more here, is the H1B. H1B is outside of healthcare, the largest used professional visa in the US. It is for individuals who are working in a specialty occupation. So the US government kind of terms that something that requires a bachelor's degree at a minimum. And then individuals who are seeking those H1B visas also have to have education in a field that's closely related to what they're going to be doing. So in the case of physicians, since the early 90s, Congress has allowed physicians to utilize H-1B visas for clinical practice when academic qualifications and licensure requirements are met. Licensing requirements for physicians are directly related to their level of patient contact and care. So essentially what that means is United States Citizenship and Immigration Services requires that clinical physicians have passed steps 1, 2, and 3 of the USMLE prior to approval of their H-1B status. In contrast, physicians in J1 status that we were just talking about only have to pass steps 1 and 2 of the USMLE. However, physicians seeking H-1B status solely for research or teaching are not required to pass the USMLE examination. And sometimes they don't even need a medical license. It just depends on if they're engaging in patient care. So that is the H context. So another thing that Chris noted, which is important for this H-1B context, is that H-1Bs in the US are typically numerically limited each year. So there are 65,000 given out, and there's an additional 20,000 reserved for individuals with US master's degrees. However, in the healthcare context, many of the petitioners, the employers in this field, are qualified for cap exempt status if they're a nonprofit entity, for example, and they have a affiliation agreement, usually it's typically with a medical school or a university. It can work. There are some research institutions also that qualify for cap exempt status, and that's a great tool. So that is an amazing recruitment avenue for healthcare employers if they are cap exempt and aren't subject to those limitations that other employers are. And often I've seen healthcare clients of mine be able to recruit people that are here in F1 student status, whether it's in the medical technologist field, even the physician, physical therapist, nursing fields, if they are cap exempt, because then those individuals know that they're going to get their H-1B visa and they're not going to have to wait nervously for the cap results that are announced around April 1st to see if they were one of the lucky few who were selected. With H-1B, similar, almost exact same requirements, H-1B1 and E3. It's a professional visa that's also numerically limited. H-1B1 is specific to individuals from Chile or Singapore. For those, even though they are numerically limited each year, I don't think I've ever seen a year where we've hit the limit for Chile or Singapore. Have you?
No, it's
Okay.
never happened.
So those are typically pretty available. So that's something maybe key to think of when recruiting, is that there are additional options for individuals from Chile and Singapore because of the treaties that the US government has in place with those countries. And the same thing applies to E3 for Australian nationals. It's also technically numerically limited, but again, I've never seen that limit be hit. So that's an option that exists. And it's a fairly streamlined process to obtain those visa categories for nationals of those countries. So with that said, we'll move on to O1. O1, Chris also gave a nice introduction to. It is a visa for individuals who have outstanding ability. So this is like the non-immigrant half of the coin of the EB1A, alien of extraordinary ability, I talked about in terms of green card processing. O1s were actually created by Congress in 1990, and they're a visa category that's available to foreign nationals who have extraordinary ability in the arts, sciences, education, business, or athletics, which can demonstrate sustained national or international acclaim. So as I hit on in that EB1A context, very similar. The person can either demonstrate receipt of a major internationally recognized award or evidence that they meet at least 3 of 10 categories, which are those same ones, like receipt of a lesser award, membership in associations that require outstanding achievement, published material, judge of the work of others, and then there are several more. I've used O1s fairly successfully across a host of industries in the last 15 years. I think the most interesting one I've done is not one that's in the medical field, but if you'll indulge me, it was for a NASCAR race car driver who got an O1 visa, and he had some national awards and major races he had won. But this is also something that works both for O1 and EB1A for, like, say someone has won a Pulitzer Prize or an Olympic gold medal or any sort of major award like that. It could be within the medical context. Maybe they've received a major award for an achievement in research or a breakthrough. They qualify for something like this, absolutely. In the actual healthcare criteria, I've done 2 in the last couple of years for surgeons who had been recognized multiple times for their achievements in making breakthroughs in surgical procedures. And then finally, TN is another category that's available to physicians. TNs are specific to nationals of Canada or Mexico. And to qualify for TN, typically the employment also has to be in a profession that's in one of the like TN eligible fields. Physician is one of those, but it only applies to teaching or research related roles for physicians. So not direct patient care, a little more limited. But for individuals who qualify in that regard, it's a great option because it can be renewed indefinitely in 3-year increments. And for Canadian nationals in particular, it's a very streamlined application process where they can just present the application at the border. So those are all positive. And if we could go to the next slide. Okay, so in the last slide, we talked about the J1 visas and the fact that individuals in that category as medical graduates are subject to a 2-year foreign residency requirement. Many of those individuals do not want to return to their home countries for 2 years following the conclusion of their residency or their fellowship. So then they're often seeking a J1 waiver. And there are several avenues for foreign physicians to secure one. And here you'll see several of them. The most commonly used is the Conrad 30 waiver. And that is essentially a state-run program where each state in the US can give out 30 waivers per year. And they all have slightly different sort of criteria and ways that these operate, which I'll talk a little bit more in a minute. But there are other interested government agencies that can grant J1 physician waivers. So typically, in order to qualify for one of these, the J1 physician are sponsored by an employer based on a commitment to work for at least 3 years in a medically underserved area of the US. So types of agencies that will grant these are things like the Appalachian Rural Commission, or ARC, the Department of Health and Human Services, the Delta Regional Authority, and then also the Department of Veterans Affairs. The Department of Veterans Affairs is a little different though, in the sense that the physician does not have to work in an underserved medical area in order to qualify for that one. So that's a benefit of the veterans waiver. So key things that these programs typically have in common is that the foreign physician has to enter into an employment contract to work for at least 40 hours per week for a minimum of 3 years in this medically underserved area typically. They must show, the employer typically must show that they recruited to search for a minimally qualified US physician and were not able to locate one. The employer also has to demonstrate that the work will take place in an area that's been designated by Health and Human Services as medically underserved, except a waiver sponsored by the VA doesn't require that. And each state, through its Conrad 30 program, is permitted to grant up to 5 waivers for work that is not located in an underserved area at the state's discretion. So there are some other avenues there. Other waiver possibilities include hardship waivers. Hardship waivers can be granted to J1 physicians who are able to demonstrate extreme hardship to a qualifying relative, including a US citizen or legal permanent resident spouse or child. So that's more of an individual application based on the physician's own circumstances, which can work. The hardship can be demonstrated through medical, psychological, financial, or educational means. And then if we could go to the next slide. Here, we're going to delve a little more into the Conrad 30 waiver because that's the most used path to the physician waiver, and probably the most, I would say, likely to succeed. So this is a complicated slide and we won't go too much into this, but this sort of outlines the process for obtaining a Conrad 30 waiver from one of the various states. And what's important to sort of take away from this is that there are 3 agencies that are involved in obtaining one of these waivers. The first one is the state health department of the state that you're seeking the waiver from. The next one is the US Department of State. And the third one is United States Citizenship and Immigration Services. So for us, when we assist a client in obtaining a Conrad 30 waiver for a physician, usually there's kind of 3 steps to our process. The first one is gathering all of the documents from the employer and from the physician who wants to take this role, because there are several things we have to determine. We have to determine if the work site that the physician is going to be placed at is in a health professional shortage area or a medically underserved area. And if it's not, we have to see if there's a flex spot available in that state, if that fits within the state's requirements. And because some states will allow the grant of a Conrad 30 waiver for a doctor that is placed at a site that is not an HPSA or an MUA, if we can show that the doctor is still serving patients that live in those areas. In Utah in particular, we've been particularly successful with that. But then we have to gather evidence of that as part of the application. We also have to gather specific documents from the physician, and we usually assist them in writing a personal statement about why they want this waiver of the 2-year foreign residence requirement. And once that's done, we file the first step online with the Department of State. It's called DS 3035. And then from there, we have to submit some additional documents, supporting documents to the Department of State and a filing fee. And then if once the Department of State has those items, then we're also filing a packet to the to the state health department, seeking their recommendation of a waiver. If they recommend the waiver, it then goes back to the US Department of State. The US Department of State then joins the recommendation, and it's sent to the United States Citizenship and Immigration Services, who then ultimately issues the I-612 waiver approval notice. So hopefully I didn't lose you there. The important things to take away is that it's a multi-step process, and if we're seeking it for a physician, it's important to start pretty far in advance, like usually like at least a year, I would say, before the person's J1 status expires, so that we can ensure that they have, you know, continuation of ability to work in the US and live in the US following the conclusion of their J1 program. And next slide, please. Okay, so for physicians, that was sort of a overview of the non-immigrant options. We're also going to talk about some options for permanent residents in the US for physicians. The main one I already gave some details about, which is the PERM process, which involves that recruitment or labor market test to be able to demonstrate to the US Department of Labor that there are no qualified or willing US workers to take the role. For that, it's again a multi-step process. So the first one is that PERM, that labor certification, and then the employer moves on to filing an I-140 immigrant visa petition for the physician, and ultimately a green card application. So this also can take multiple years in this path. It depends on where the individual is from. If they're from a backlog country such as India, from start to finish, it could be 12 years. So it is an option that exists, not always the best option. Another option for physicians in particular is the physician national interest waiver. That has, I would say, some benefits in the sense that the employer can skip the PERM labor market test. The Physician National Interest Waiver was actually created by the Nursing Relief for Disadvantaged Areas Act of 1999. And for individuals or physicians that are working in an area that is deemed to be medically underserved and their work is deemed to be in the public interest, they can be granted this national interest waiver. However, they have to agree to work in that underserved area for 5 years. So that's a pretty lengthy commitment. Two of the key components that the physician has to secure in order to be granted this PNIW is a public interest letter from the federal agency or state department of public health about their work being in the public interest. And they also have to be able to produce an employment contract executed within 6 months of filing the PNIW, or Physician National Interest Waiver, that is for a 5-year duration. For individuals that meet these criteria, though, this is a great option because if it's granted, we can skip the labor market test and it gives them sort of a quicker ability to secure a priority date. Although this would be in the employment-based second visa category. So not as fast a path for individuals from India or China who may instead be more interested in alien of extraordinary ability that we talked about before because it's EB1A category and usually has a shorter wait to securing a green card. I have not actually filed too many PNIWs. I think I've only had 2 in my career. I don't know if you've done many, Chris?
We have done quite a few. I'm thinking of one organization in particular that just had facilities throughout the country, in particular in shortage areas where we were able to file a lot for their physicians and get them lined up in good places. There are plenty of such options in the West, as of course, Wyoming, Montana, etc., have wide open spaces of underserved areas.
Yes, absolutely. It's funny that you mentioned Wyoming. I actually recently corresponded with their Office of Rural Health about Conrad 30 waiver availability in Wyoming. And the person who administers their program told me that they receive about 5 applications per year of their 30 spots. And the most that she's seen in 15 years was 10 in 2012, 2014, and 2016. So it's very available in Wyoming in particular, and they're like, yes, please send us more applications. Utah also, we've worked with quite a bit with the Conrad 30 waivers, and they often don't use their full quota in a given year. And they're interesting in the sense that they reserve 20 of their slots for those working in facilities located in health professional shortage areas, but they allocate the remaining 10 slots for physicians participating in non-HPSA areas who work with underserved populations. So they're sort of acknowledging that not every one of these physicians is going to have a work site that's in an HPSA, but as long as they're serving individuals who live in those areas, then they're still willing to consider it, which is a nice flexibility. Okay, next slide, please. Okay, moving on to physical therapists. This is going to start to feel repetitive, I'm afraid, at this point where we work through the non-immigrant and immigrant options. Physical therapists have many of the same ones as doctors. I will start a little sooner here because I have found that physical therapists often are in the US as F1 international students completing physical therapy programs here in the US. And the great part about that is individuals who are in the US as students, upon completion of their program, are often granted employment authorization for at least a year and sometimes up to 3 years in optional practical training or OPT. So individuals who have that OPT work authorization can be employed by US employers. And that's a huge advantage to the employers themselves because it gives the employers a chance to sort of get these individuals in, see, what they're capable of, if they want to retain them long term. And if so, then they can start to think through how to do that by transitioning the person or assisting them in transitioning to another more long-term non-immigrant status, such as H-1B, H-1B1, E3, or TN. H-1B, we talked about before, is a typically capped non-immigrant professional visa. Physical therapists, almost 100% will meet the specialty occupation criteria because it's a Schedule A occupation. It requires usually at least a bachelor's degree, if not a master's degree, to be a physical therapist. And for employers that are CAP exempt, they can secure these H-1B visas for physical therapists any time of the year. For employers that are not CAP exempt, right, that are either for profit or don't have an affiliation with a university, then if they're seeking H-1B for a physical therapist, it would be subject to the cap, which occurs every year. The lottery occurs usually between around March 1st and March 15th. This year it happens to be March 6th to March 22nd. And then USCIS announces the results of the lottery usually around April 1st. And individuals who are selected can then have H-1B petitions filed for them by June 30th. H-1B is usually valid for 3 years initially and can be extended for an additional 3 years for a maximum of 6 years in that status, subject to certain exceptions. H-1B1 is exactly the same, but for nationals of Singapore and Chile, as we discussed, and E3 is also extremely similar and just for nationals of Australia, and less limited in that the caps for those are not typically reached. TN is also a great option for physical therapists. That's for individuals who are nationals of Mexico or Canada. And for those, there's no cap. And that status is granted in 3-year increments and can be renewed indefinitely. So that's a great path as well for nationals of Canada or Mexico. And then finally, we talked about this somewhat earlier, physical therapists have a immigrant visa option through Schedule A, which is a basically streamlined version of the PERM process, where the US Department of Labor has taken notice that there are not enough US workers that are physical therapists. So employers don't have to go through the labor market test to secure an employment-based green card for physical therapists or nurses, which I'm sure Chris will talk more about in a minute. And the benefit of that is the process goes a lot more quickly. So instead of it taking 2 years from start to having an I-140 approval, it takes more like 8 months, sometimes 10. And then the person, if they're not in a backlog country, can move on to filing their green card. So it's a huge plus. One thing I will note that's a little complex about physical therapists is they have certain certification requirements. So typically anyone who's involved in direct patient care, if they're a foreign national, has to have a visa screen, which I learned in preparing for this is actually a trademarked term that CGFNS has coined. And what that is an organization that vets the person's foreign education, their English skills, and everything to show that their foreign education is equivalent to someone from the US working in a patient care role. And there are several different job classifications that are subject to this visa screen requirement. It includes physical therapists, obviously physician assistants, speech language pathologists and audiologists, medical technologists and technicians, occupational therapists, and nurses. So this is important because this is just something to be aware of that the individual needs to secure typically ahead of time, and it can take months. So it's something important to just keep an eye on. Okay, next slide, please.
All right. Well, so as we dive into this stuff, we recognize that some of this is wildly technical. And so my thought is that we'll kind of keep it higher level here and just sort of talk you through how these things can play out, how they can work for you. In particular, I'm thinking about a situation where a hospital network reached out to us last year and they said, we've got a problem. We need hundreds of nurses. We just have a terrible shortage. What do we do? And the good news is that there are options to bring those nurses in. But one thing in particular, and as I'm sure most of you are aware, the Philippines is kind of the place to get nurses these days when you're looking for foreign nationals. And the reason for that goes back to the World War I and II, where they had a very comparable nursing program established and kind of created a pipeline, which has remained intact ever since, where nurses are coming to the United States now from the Philippines with very comparable educations. They speak English and they're ready to go upon arrival. The question is, how in the world do you find them, right? From the recruiting perspective. We have some hospital networks out there that we've worked with who do it on their own. They set up an office out there, they do the recruiting, they kind of screen people and so on. There are organizations out there that do it and haven't done it right. So I'm also somebody who has headed up a whole lot of compliance related or investigations related matters. You want to make sure you get this right. I'm thinking of one hospital network in particular that did it on its own. They kind of cut corners. They didn't follow the rules. And all said and done, they ended up being investigated by the Department of Homeland Security for having cut those corners. So make sure you get it right. If you want a suggestion after this, shoot us a quick email. I'm happy to send a couple of suggestions about organizations out there that do a great job, really good job of finding individuals, vetting them for you, and then saying, okay, we got 200 nurses ready to go. And so happy to help you with that. But what we don't want you to do is have you be one of those organizations that didn't get it quite right and get in trouble. And so, right, healthcare certificates are going to be necessary for your nurses as they were for the doctors and for your physical therapists and all of that. So just keep that in mind. And if they're not coming from one of the traditional English speaking countries, they also need to pass the English tests so that they can show that they've got adequate fluency in English, so they can follow directions, ascertain what their patients are saying, all of those important things. Let's move on to the next. And so there are the temporary visa options out there for nurses. And a lot of universities, or hospital networks that work with universities are starting to tap into that more and more. For example, if there's student visas in a nursing program who are on an F1 visa, they can work with you for up to 20 hours per week. And as they graduate, as we've mentioned, they can get optional practical training. Now, there is a complexity. For an H-1B visa, normally you have to show that the person is coming to fill a specialty occupation. Specialty occupation is an occupation that's designed or defined normally as an occupation that requires at least a bachelor's degree or higher. Well, as you know, most registered nurses do not require a bachelor's degree, unless they're in one of these more advanced type positions, right? Such as CNMs, CNSs, CMPs, addiction, cardiovascular, is the higher caliber nurses that had to go through a little bit more education and so on. They will qualify for H-1B visas along with H-1B ones and the E-3s. But normally the H-1B itself is not going to be a fit for your run-of-the-mill registered nurses. There are other visas out there. There could be one-time type situations with the H-2B for a seasonal kind of need or for a one-time urgent need where there's a major influx. There are H-3 training visas where some hospitals have turned to those to bring nurses in, train them. It's only valid for 2 years, however, so we always have to play with, well, what other options are out there? And as you now know, the TN visa is available for Mexican and Canadian nationals. And of course, they could come in and work with you too, but it's kind of hard to find nurses in those countries just as it is in this country, which is kind of what takes us to the next slide here and what most organizations end up doing. And that is taking the green card route. Schedule A is available for nurses, which means that nurses do not normally have to go through what's called the labor certification process. In other words, we don't have to show the government that there's a shortage of nurses. The government already accepts that reality, that there is a nursing shortage in this country. So what we often end up doing is working often with organizations abroad in the Philippines, for example. They will have a hospital that says, I need 200 nurses. I'll say, great, we can get that rolling for you. And so we get the paperwork filed for them. That process is not as fast as all of us hope. It's going to take a little bit of time, but once that comes through, then we've got sort of a next step of waiting until a visa number becomes current. And there are backlogs, unfortunately, in what is known as the third preference category. And that backlogs can sometimes drag things out. We have a couple networks out there that I'm thinking about where they said, okay, we recognize that we may be dealing with this shortage for the next year, but at least there would be hope for us in the future. And so in those situations, what we've done is we've brought nurses in with the understanding that it might be about a year before you get them on your team. But wow, once they arrive, it's a wonderful thing. And I'm thinking about one hospital network last year that brought in 900 nurses because they were just so short and needed to bring them in. But those nurses have now been arriving and they find themselves in a position where they say it's working. Our staffing shortages with nurses are finally coming to fruition and we're in a position where we feel like we're in a good spot. So when it comes to the final step of getting a green card, there are two ways to do that. One way is when people are in the United States, say they're on a TN visa or whatever the case may be, we would go through this process while they're working in the United States, and then we would adjust status once we get far enough down the road where they adjust from temporary to permanent status. Or if somebody's abroad and we decide, okay, we're just going to do the whole thing while they're abroad and take about that 1 year that I was telling you, then they come in and they go through what's called consular processing, where they get their permanent residency adjudicated or finalized at a U.S. consulate, such as the U.S. Embassy in Manila. And then as they enter the United States, they are permanent residents, meaning there won't be any expiration on their employment authorization in the United States. They come in, they start working with you, and voila, you've got nurses who are working with you. So again, the plus of this is that it gives you people who can stay permanently. The negative is that it can be a long road. It takes about a year to get this rolling, and then it does get rolling. And some hospitals just say, okay, we're going to bring in 100 a year or something. And so they always have kind of a new influx of nurses coming in the future. You can always abandon this if things were to change and you felt like, okay, we started this, but now we're not so sure we need 100 nurses in 2025, say. You could just drop it and say, well, great, you got the 100 that you needed for 2024 and you're good. So anyway, just letting you know that what we're seeing out there and what some of the hospital networks are doing to overcome this dire and constant shortage of nurses. Next slide. just finally, as we wrap this up, we'll talk to you a little bit about medical technicians and technologists. These people qualify for all the usual categories. So unlike nurses, it is deemed that this is a specialized occupation for everybody. Normally requires at least a bachelor's degree for somebody to become a medical technician or technologist. They don't appear on that Schedule A list that I was just talking about, where you get to kind of streamline the green card process. So you'd have to go through a regular green card process. So what most hospitals are doing is they're relying on those temporary visas, the non-immigrant visas, to get people here. And then after a year or so of testing out one of their techs, they decide if this person is really somebody that they want to keep, and then they take it from there. So again, what are the requirements? Well, they have to have a degree that's comparable to a US degree or have been educated in the United States. There are some fields that do not clearly qualify in the tech range and others that do. And we're trying not to go too far into the weeds with you here at this stage. But this is kind of the lay of the land in terms of what's available out there. So we want you to think about that in terms of, okay, what could we do? You got people who could come on the non-immigrant or temporary visas, or you could just jump directly into the immigrant visa approach. I will tell you that most hospital networks decided, at least when it comes to nurses, that they want to just bring them in as permanent residents because the visa options are just not as good. H-1B is not really available. They're not finding people in Australia, Singapore, Chile, Canada, Mexico, where there are the free trade visas that we've talked about, the TNs, E3s, etc. So as you think about it, just think in those terms. If you want people immediately, you're probably recruiting on campus, trying to find people and then figure out what kinds of visa categories some of these people might qualify for. If you're thinking, no, we've got major shortage needs and we want to bring in a lot of nurses and we want to do it now, recognize that it will be a ramp up time, that you won't get them immediately. It'll take about a year. But eventually they do make it, and what an impact they can have. And again, happy to share with you the information of that organization. There's one in particular that stands out there where they do the recruiting, the vetting, they get everything, all the paperwork in order so that it's ready to go. They just reach out to us to do the legal piece of it. And then as the process gets to a close, they guide them through the US Embassy in Manila, where they end up getting everything completed there, where they get their permanent residency. And they even provide training courses on what to expect in the United States so they can assimilate better once they're here. So they'll teach them about, all right, this is how things work here. And you do have to follow traffic laws. You can't do this, you can't do that, etc. So that as people arrive, they're kind of ready and have an understanding of what life in the United States is all about. So that, folks, is our crash course on all things immigration in the context of healthcare. We did not see any questions come in through the chat, but we are certainly available to answer any of your questions as they arise. Please don't hesitate to reach out to us. We are happy to answer your questions and just kind of walk you through how these issues might relate specifically to your organization. Thank you, everybody, for your time. Yeah. Take care, everyone. Bye.